What's up, everybody? Welcome to thctrust.org. This is your brother Sylvester Moore Ale. Also, many of you know me as Tex Masson. And today I'm gonna give you an example, give you a real live example of an administrative process that I arranged that was successful in discharging debt. Now, if you're a member of thctrust.org, if you're in the premium subscription group, you have access to all the templates that I'm going to provide you in this brief lecture. And I'm taking into consideration that you've already attempted to discharge a debt before. You're familiar with the bankruptcy, how we're operating under bankruptcy statutes per se. You're familiar with notary presentments. You know what a notary protest is. And you know what's generally referred to as administrative procedure. This is an advanced topic. And there's always more than one way to skin a cat. This is the only way that I know that has worked for me, and there is no luck involved. This was built on trial and error and learning from administrative presentments or tendering private negotiable instruments in the past. You know, building upon prior attempts is how I got to this success. Now, if you don't already know, if you don't have an account, click right here where it says create an account and create a free account. And if you want to join the premium subscription group, then that's still $32 per month, or for however long you want to stay subscribed. Now, these are kind of good prerequisites. If you look on the right side of the website here, you see Credit and Debit Instruments 1. I want to recommend that you click that first. You can go through all of this on this page if you would like. But what I want to point out to you, what's most important, is that you click this right here. It says read this download. Click that right here. And that's going to take you to, that's going to download. It's going to download this set of documents called Freely Given. And this is study material for you. And by the way, anybody can do this. You know, you don't have to be a you don't have to be a paying member to have access to this. So you just log in, create the free account, go under Credit and Debit Instruments 1 and click this document called Freely Given. Or you just click, actually you click right here and it'll download these documents. I've mentioned these before. These are excellent reads if you really want to educate yourself. If you're somebody that's studying and not just blindly looking for a remedy, these would be beneficial for you, because I read these and it gave me a more in-depth understanding of how bills are used in commerce, how notes are used in commerce. Go look at these and you know, make sure you read these. Specifically, at least read 1. It gets good once you get around 10, where it talks about public and private, and then 11 talks about the money order, and then 12 talks about a particular money order, which is Executive Order April 5th, 1933. It goes into the bankruptcy. Then it goes into the bond and HJR 192, and it explains, you know, while it's going through the history of what occurred in a commercial system, it's also explaining how these bills, bonds, and notes work. Now, that's not going to tell you anything specific on how to discharge a debt, but it'll help you in your overall understanding, because you're going to have to develop strategies for these type of things. So that's Credit and Debit Instruments 1. The other thing I want to direct your attention to is, I've said it before, but now you can see it, HJR 192, Public Law 7310. 48 Stat 112 that people infamously claim is the way to discharge debt. Well, it has been repealed. It's been repealed before I was born. This happened in 1977, I believe. So this is probably not what you want to use as an authorization for discharging debts. It's not to say that you don't have a right to discharge debt, but you probably don't want to say Public Law 7310 because the public law itself was actually repealed. Now I'm going to copy this right here. Go to Google. Put this in here so you can look at it real quick. There it is, right at the top. Scroll through it. Go through, it's 91 Stat 1229. Here it is. I guess let me move this over so you can see it better. All right, and when you look down here, it says it right here in section C at the very bottom. The joint resolution entitled Joint Resolution to The joint resolution entitled Joint Resolution to Assure Uniform Value to the Coins and Currencies of the United States, approved June 5th, 1933, shall not apply to obligations issued on or after the date of enactment of this section, approved October 28, 1977. So this is a law that was enacted just like Public Law 7310, and they're saying that the joint resolution, and that's HJR 192, to assure uniform value to coins and currencies of the United States, June 5th, 1933. That's HJR 192. So that's why we don't cite that. So what we do cite, and well, we'll show you when we get to that, because that's also important. See, I always looked at ultimately the enforcement, the ultimate impact of discharging anything is the citation of authority that you're using, because there's a lot of things that lead into why we're under a bankruptcy, or you're a creditor, we're not using lawful money. There's a bunch of different circumstances that end up to why there exists a remedy, but there actually has to be some citation of authority to enact the remedy, is at least the way that I always viewed it and the way that I always looked at it, right? So I do believe there was a time when HJR 192 was the remedy, and for reasons of whatever, they closed it down like they always do, and they shift the remedy into a whole nother angle. So just pay attention when we get to that part, and pay attention to the codes that we cite, and then and I like everybody's feedback on this stuff also. So and I hope you're still rocking with me. This might be over some people's head, this might be under some people's head, meaning I know there's a lot of people out there who already are successful when it comes to discharging debts. They have entirely different means and methods that they use, and there's other people who may not have been successful yet, but they're extremely knowledgeable and in depth. So when you take the fundamentals of this approach that I'm going to share with you, just know that it has already been successful, but to ensure that it continue to be successful, you can also build on top of it. You can share with me the things that I have not considered that can also be done in tandem, because as we will see, discharging debt is multifaceted, and you have to address it with multiple layers. The more stronger you address the matter, the more likely you are to have success on a first attempt, first time through, without having to worry about going into any types of enforcement. And fortunately, I have a lot of faith in this method that I'm about to share with you. So I hope it's beneficial. But anyway, this is credit and debit instruments 1, credit and debit instruments 2, and then to get into credit and debit instruments 3, you have to be under advanced topics, And this, what I'm about to cover, is going to be under credit and debit instruments 4, which you don't see here yet, but that's where you'll find it. So can you understand how a mortgage or a car note has a past, present, and future liability? For example, one receives a bill every month with an amount due for services received on the account in the last 30 days. The amount generated in a payoff statement is the present liability on the entire account, right? So you have this present liability, and then you get a bill for past services on the account. So, and then every month they're going to adjust the account. Well, you're going to send a new bill, and then if you ask for a new payoff statement, there's going to be adjustments that's made. So every 30 days you get a new bill. But the point I'm trying to get you to see a little bit is that there's past, a present, and a future liability going on in these reoccurring debts, if you will. So if, at the same time, when they send you a bill because your payment is going to be due for the present pay period, you can have a payoff statement with a different amount. These are different types of liabilities or obligations on the account. So that's all I'm pointing to. And if you download it freely given, those documents that I pointed out earlier, then you would better understand why I'm looking at things this way. And this is how I had to look at things to help develop this fundamental method for discharging debt. Looking at it that I have to satisfy the past, the present, and the future liability on this account all at the same time using these commercial instruments. So discharging a debt is multifaceted. There isn't any one way to do things. While I always hope for positive acknowledgement from the fiduciary receiving my presentment, ultimately I'm building a record in fact that will reverse any liability should the fiduciary not perform. So when I speak of the fiduciary, I'm talking about the CFO of the organization who will be getting the instruments, who's supposed to exercise ordinary care with the instruments or process the instruments a certain way. He has to present the instruments for payment, and either he has to adjust his books and records, or he has to come back and prove that the instruments have been dishonored. This is the normal course of business that I have to expect and be willing to hold him accountable for, right? So what I'm doing is I'm building an enforceable record. This is why we use registered mail when we send private instruments to the fiduciary, or you use a private courier and you get a written receipt for delivery. And that's something that I did in my process. I kind of did both. Well, I'll talk about it when we look at the documents. And ultimately, another thing to kind of think about is you don't always necessarily need to do everything with the notary presentment, because that can get expensive. You have to look at first what the objective is that you wish to accomplish by your administrative procedure, and then figure out what evidence needs to be gathered. So in this example, I didn't do a notary presentment when I presented the notes and the instruments for discharging the account, because where I was operating from, notaries are allowed to do protests. And a notary can do a protest. You don't have to have any notarized certificates or anything for a notary to do a protest on an instrument. Just to, so basically what I knew is I could simply, what's most important is either they're going to honor these instruments or they're going to dishonor the instruments, one way or the other. And if I need to get a record of that, all I need is the notary protest, right? Fortunately, and that was just, that's just one angle how I'm showing you that what you're actually building is a record of evidence. Fortunately, this procedure, there was success and I didn't have to get a notary protest. So I'm just showing you that, be fluent and kind of realize what objective you're trying to accomplish first before you start building your administrative procedure. So it may also require you to look at what a debt collector is required to do when you pay off a debt, whether it's a mortgage or a car note. What type of release of lien or claim or documents are they supposed to file, and what does the state say about satisfaction or tender of payment, the commercial code under that state. Just looking and familiarizing yourself so that when you actually do prepare your notices and your documents, you're hitting all of those precise points, making sure that the obligation is there on a fiduciary that they have to perform, right? Because other than that, you just have to present the right type of commercial instruments and the right authorities. The authorities being the codes that you cite to authorize the exemptions. So let's see. So ideally, the best time to discharge a debt or a contract is before the first payment becomes due. So say, for example, I go purchase a car and I extend my credit and I create a debt contract, right? So ideally, there's going to probably be almost about 60 days, I think, before your first payment or your first bill comes in under that contract. And I would say ideally, the best time to discharge that debt is, discharge the whole entire debt before the first payment is due, right? For a couple of different reasons. One is they never, if you give them a settlement, not just discharge it, but you letting them know, you say you give them a notice of tender and a settlement offer, and you're breaking down the terms or the instructions or the conditions or whatever, you're letting them know that it's discharged and settled. So whether they are in agreement or whether they want to go into argument and dispute you, they don't have any record that you were ever in default for 30 days or 60 days or 90 days. So this is kind of a defensive mechanism because it'll prevent them from being able to report adverse information of defaults on your credit report. They won't be able to collect the 30, 60, and 90-day delinquencies and defaults, the records that they need to either forfeit or seize your property or even to put negative marks on your credit report. And as long as you're building your records correctly, you have evidence that you've tendered the payment, you have a receipt in some form or another, whether it's the green card from the post office or a physical receipt, right? And so that you have the dates, the account has been discharged. You're going to be able to remove all that stuff off your credit report if it even hits your credit report. And if you challenge it, it's going to come right off. But this is, it's bigger than the credit report, but I'm just trying to also get you to understand that even though we're hoping for a more grander success, you're actually building a record to support, if you have to go about things a different way. So here's something else on that. Let's go look at these documents real quick. Now, what I'm reading from here on the screen, this is going to be basically the same thing that's on the website, And down here at the bottom, if you're looking at this on the website, at the bottom here, you can click this and you'll see the actual templates that I'm talking about or that I'm kind of referring to when we're looking at this fundamental approach for discharging debts such as mortgages and car notes. Now, this particular scrubbed template, let me do it like this. I use this for discharging a car note. So just let's look at the components right quick. We see there's a bond here, right? It's a certification of trust. Don't get wrapped up around that. That wasn't really too important. It was just more or less there because sometimes that might be a requirement to get a medallion stamp on a commercial instrument. And your medallion stamp could go on the front or it could go on the back. The notice this bond is issued from a trust, Doe John, trustee under declaration of trust dated whatever, doing business as John Alex Doe. It's just always better when you're dealing with bonds to issue the bond from a trust. I think a private express trust is the best thing to do. But in this case, you know, if you're going to a bank like Chase or Wells Fargo, it's already difficult for them to give you the medallion stamp service. But if you're trying to get the medallion stamp service on an instrument issued by a trust, they're not going to do it unless you have that same, unless that same trust has an account open with them. So this is why it's ideal to use a private express trust and then get a DBA for that express trust. Now, by the way, if you're a premium subscriber / member on thctrust.org, if you go under the trust documents, the common law trust, hold on, if you go under the trust documents, that's the type of trust that I'm saying would be ideal to use. There's one there, and as a matter of fact, I think I've linked to it here somewhere too. Oh, I know where it's at. So yeah, right up under here. Actually, I was coming down to it. So on this same page, if you're on the page or if you're wherever you're looking at this, you can look down here. And this is just, you know, it's an example, get you started. You might have your own trust. There's all types of other trusts. I'm not saying this is the only type, but this is just a basic, shoot. Let me get to it. So it's a private contract and express trust agreement. And I just kind of went through this. So this was the same thing that's under the common law express trust stuff under the trust menu. But I just went through it again recently and cleaned it up real good, fixed a couple things in it. So it's a good trust to use for the purposes of this, you know, for banking purposes only. That's pretty much what I use it for. I set up the trust account so I can get the service of a medallion stamp if I have to discharge something. Quite frankly, I don't see much better use for banking than that. Now, on another note, you don't necessarily have to go that route and open up a bank account for a trust. If you have a membership with a credit union that offers medallion stamp or signature guarantee services, a lot of times it's a lot easier. You can still issue your bond or commercial instrument from a trust and get them to put the medallion stamp signature guarantee on it. Now, let's go down here. So let's look over the documents real quick. We see there's a bond. Most important thing to really realize is that the bond is issued from a trust. This would be real bond paper, right? So when this is printed out, it's printed on real bond paper. If you look here, where is this bond going to be paid out through? Who's the surety, right? John Alex Doe, principal creditor, private offset account number. Then you have an account number. The bond number, you have a number for some private registered offset bond. And then you have a registered mail number, which would be the routing number or the account number for where this bond has been deposited with the Treasury. That's how I would do this. But again, it's a bond. So you could do some type of a gold bond or a silver bond. But if you notice, this bond is numbered 002. and it goes by and through private offset account number, and then you have a bond number or whatever. So this is just connecting the dots. And then if you say, okay, well, what is this other bond? That's your master discharge indemnity bond, or whatever you want to call it, your secured party creditor bond. But this is what links you into the whole HJR 192 substance-backed currency and all the different reasons of why you put this bond in place to, as a creditor with the United States. So that's what this is linking to in this example right here. But again, I would say I would really also explore creating your own silver bonds and gold bonds, because you can also do that, and I think you would get the same results. The thing about getting a medallion stamp on your commercial paper, which is going to be quite difficult, I have to be honest with you, it's going to be difficult. But if you do get it accomplished, then you have to understand what it means. It means, for all purposes, that instrument is cash, and it can be used as cash for the purposes of how you used it in commerce. So in this example, with the car that was being discharged, we have $100,000 bond, which this was pledged as collateral, and then this was already signed, by the secured party or by the trustee, the authorized person, and it was already medallion stamped when the CFO received it. All the CFO had to do was fill in the proper amount, right? Because this is treated as a cashed item, basically. Now, how do they account for it and all of that? That's for CFOs to know. And the other thing is, all this is commercial paper credits and debits, really. So I just make sure that the contracts and that the mechanics of the instrument itself make sense, right? That everything connects the dots. But at the end of the day, these are commercial instruments for credit and debiting transactions, and they just have to make sense. You know what I'm saying? I'm just kind of throwing that out there because there's not just one way to do this, but hopefully that'll, be helpful to someone. So they put their guarantee on this. When you put a guarantee, they're putting another layer of insurance on this instrument. Now, this would be the instrument that the CFO would have to dishonor. Now, this instrument, there's other instruments, for example, the bill of exchange, which we haven't looked at yet. We're going to look at the bill of exchange. That's a part of this transaction. So the bill of exchange is like your accept for value paid to the United States Treasury, redeem in lawful money for credit to whatever. Those are payment instructions. That's your acceptance on a debt and your written payment instructions on the United States Treasury with the treasurer as the fiduciary. So that qualifies as a bill of exchange. So but ultimately that's where ultimately we're discharging this using the laws to discharge things. But anyways, this is this is what this is the instrument that I had created. So up to this much was pledged. The guarantee was down here so that he can write the amount in on this cash item instrument. And all of this will end up going back to the Treasury. That's why the instructions are there, or down here. The whole bond will end up going back to the Treasury to get ledgered against your secured party creditor bond. And you might file a UCC-3 on this. Now, not to really get lost in all of this, because even if you didn't do all of this, you're still more than likely going to have success, but you still should do all of that, if it makes sense. What will yield the success is the obligation to accept or reject payment, right? So we just kind of looked at the bond. That's not everything about it, but I just want to go through here. We see there's a bond in this presentment. Then you have this certification of trust. This certification of trust really is the page that I put on top of this bond, or I might do a memorandum of trust, certification of trust, or some other type of indenture. But this certification of trust is basic. It says the name of the trust, the date of the trust, the original trustee for the trust. It's basically demonstrating the basic, it's certifying that this trust does exist, even though this trust would have to have an account with the bank before the bank did this. It's just one of those documents sometimes that helps you get through the scrutiny that they will do, because it might be, unless you have a strong relationship with a bank, it might be hard to do this. But it just helps you get through that scrutiny. The more professional your documents is, the more you know what you're doing, the more likely you are to be successful in getting a medallion stamp on your bond. So then there was that. Then there's a fiduciary authorization and appointment. You know, nothing special. Actually, there is something special about this one. The only thing special about it is I went through it. I took the time. I put things in there that I thought was important. But this is an important part of your contract. There's a lot of fiduciary appointment documents out there. You need to have one in there, right? So these instruments and presentments are made in good faith with clean hands and good consciousness. Legal references in these notices are provided for educating and giving perspective to the trade methods of the trust, for guidance to fiduciaries to understand the relevant policies from which duties may arise and are accountable under the laws of the United States of America. Nothing in these instruments are intended to prevent or otherwise restrict the fiduciary from performing according to the internal procedures of his or her official duties. With privacy is required by law. Names are not to be released, nor other personal identifiers, nor methods of trade. These are considered trade secrets, and in so doing, you may be in breach of a trust. Any information you receive from records related to this transaction is to be held in strict confidence and privacy. The fiduciary is indemnified when disclosing information as required by law or otherwise necessary to carry out the instructions provided. All right. So I'm basically telling them that everything I'm doing too is a trade secret. So you have to be hush-lipped about this, except for where the law requires you to not be hush-lipped. But other than that, confidence is important. So anyway, some other provisions in there, but you have to have a fiduciary appointment. You can even include your IRS Form 56. I didn't include that. I just did a written fiduciary appointment under the Powers of Appointment Act. Now this is, you can adjust this, but this was the key part of everything. And this was where a lot of the emphasis went into, and you'll see how I structured the transaction. You'll see the strategy and what I did. And at the end of the day, this set me up for one thing only. Either they were going to honor these commercial instruments and discharge the obligation, or they were going to reject them. And under the UCC Article 3, Section 60 something, 603, I think it is, but you can go look under there. Basically, if you tender payment to the person who's entitled to enforce the instrument and they reject it, then there is discharge. And that's all I'm trying to do, is discharge it. So I'm giving them a presentment under the laws that requires them to discharge it, and then I'm still giving them payment at the same time. That's what you'll see when we get through the process. And if they want to reject it, then there's discharge anyway. So at the end of this procedure, you end up with a lawful discharge no matter how you put it. And then after that, you take it a step further. Once you either get your notary protest on the instrument or you get their positive acknowledgement, right? Then you can issue the 1099-C. As you're a creditor in this transaction, you are always a creditor when you extended your credit to create the debt obligation, and now you're discharging it. So you can issue the 1099-C on the transaction. Now that's further self-authenticating record, and it's a notice to the other party whose tax ID number is also on the 1099-C that the debt has been canceled or extinguished according to your process. So this is the notice of tender, and I was going to call it a settlement offer, but you only get two titles, so I said payment instructions and notice of tender. And the tender is an offer within itself. And again, Another thing that you have to think about when you're dealing with private negotiable instruments, bills of exchange, because your A4V is or your banker's acceptance is a bill of exchange, which is a private negotiable instrument. So you also have to think about payment orders to, from, or on behalf of the Treasury creates a certain situation where the fiduciary now is in possession of federal funds. So they're not always in a position where they can reject or not respect what you are doing, because there are certain financial laws that applies to chief financial officers, certain treasury regulations that apply to them, and just as sure as they have to get the business license from the Secretary of State, which is basically following suit from the Department of State of the United States. So they fall under these financial laws, and this is, you have to consider these things, because there's no such thing as them just, oh, they just didn't honor my instruments. You know what I'm saying? You have enforcement built into this. But again, I think if it's done right, you're not going to have to worry about having to do any excess enforcement, because I think it'll be accepted. So, dear Dan Keymont, I am authorized to pledge the enclosed instruments as payment and discharge in full acquittance of the above account. And there's the fictitious account number. And remember, as we said before, we're discharging it before the first payment is due. Now, please find the enclosed, or something like that. 1. Payoff letter dated June 16th with written acceptance and payoff instructions. That's what I should have said, because your accepted for value is a written acceptance, but paid to the order of whoever, those are your payment instructions to the fiduciary who's responsible for paying, which would be the United States, it would be the treasurer of the United States Treasury, where you put your bond. That would be the fiduciary responsible for paying the payment order, or your accepted for value. So that's your first instrument. It's a bill of exchange. If you look up the definition of a bill of exchange, it's going to tell you it's a written acceptance and a payment order, basically. You go Google it. Google bill of exchange and see what it says. So that's your first instrument. Then you have the fiduciary appointment and authorization letter, which this is. Then you have U.S. postal money order. And if you notice, I have 3 of them here. So these are 3 instruments, or 4 instruments. Your A4V and 1, 2, 3 U.S. postal money orders. So now, this goes back to why I was saying you want to discharge it before the first payment is due. So you just extended your credit and you created a contract. Now you have to perform under that contract. These 3 payments represent the performance obligation under the contract, because you want to discharge the contract not when it's already in debt, but before any debt is due. So the whole idea is, say you open the contract in December, your first payment is due in January, and then February, and then March there's a payment. So soon as you get the first bill, you create 3 money orders. And what you're doing is you're tendering them all at the same time with the settlement offer. What you're doing is you're setting off the obligation under that account for 90 days in the future. Meaning, for the next 90 days while you work on your administrative process to discharge the account, there is no liability. I mean, basically, they can't bill you. They can't send you any collection notices, because there's no debt on the account for 90 days. So if you tender these 3 prepaid payments and you post date them and you give them in the instructions that this is January, February, and March payment, what you're essentially doing is setting off the present liability, or you're setting off the obligation, the performance-based obligation for 90 days off into the future. So at the same time that you do that, you also want to have a payoff statement. So you would have already requested a payoff statement. The payoff statement is what you're going to use your bill of exchange for, or your accepted for value, right? Let me scroll down here real quick. And this is just an idea of what we're saying with the payoff statement. Deposit to the United States Treasury. I probably should have put accepted for value at the top. Accepted. What are you accepting? You're accepting the debt obligation, the total liability to pay off and discharge the account. So this would be written on the back of the payoff statement or attached to the payoff statement. Deposit to the United States Treasury. What are you depositing? The debt itself. Just like you deposit debt notes in a checking account. Whenever you deposit something in an account, they spit you out cash, or they spit you out a check or a money order, unless you do for deposit only. So you deposit this, accept this debt, deposit in the treasury, redeem it in lawful money, and then it pays out to the order of John Alex Doe for further credit to, and this is where you would put the debt collector's info, right? And these are the payment instructions that you give to the CFO, and then you provide these citations of authority, which I believe are very important. It's 12 USC 95 A2, and we can look it up real quick. 50 USC 4305 B2. I'm only going to read one of them because they both say the same thing. They deal with commerce and a foreign creditor's claims against the United States Treasury, in part based on the gold clause, amongst other things. This Trading with the Enemy Act is a whole bunch of financial laws that have been compiled since 1917 that deal with the internal parts of credits, debts, and property in the United States. So this is where we find the remedy buried in for discharging debts, basically. So let's look at 12 USC 95 A2. And this is on our, so notice Title 12 is banks and banking, national banks, regulation of the banking business, powers and duties of national banks. Now remember, you're dealing with chief financial officers of financial institutions who's under these regulations, and they're under the laws of the United States. So here's what 95A2 is. Any payment, conveyance, transfer, assignment, or delivery of property or interest therein made to or for the account of the United States, or as otherwise directed pursuant to this section, or any rule, regulation, instruction, or direction issued hereunder, shall to the extent thereof be a full acquittance and discharge for all purposes of the obligation of the person making the same, and no person shall be held liable in any court for or in respect to anything done or omitted in good faith in connection with the administration of, or in pursuance of, and in reliance on this section, or any rule, regulation, instruction, or direction issued hereunder. Now this is again what I'm using on the payoff statement, because I want to discharge the payoff statement. See, so we're dealing with the past, present, and future liability on the account is actually what we're doing. So if you notice, there's 5 instruments here. There's the bill of exchange on the payoff statement. There's these 3 money orders that set off the performance-based obligations for 90 days into the future. So there's no debt owed when you tender the bill of exchange and the bond for discharging any present or future liabilities. So now you're fully satisfying the account. This settlement offer with the enclosed instruments are items eligible for adjusting entries in the ledger of this account. CGAAP, extinguishment of debt. And you guys can Google that too. The generally accepted accounting principles extinguishment of debt. The enclosed money orders are for setting off the debt obligation for the months of June, July, and August. The payoff statement dated June 16th, 2020 is endorsed as accepted and discharged in full according to the payment order dated June 18th, 2020, citing 50 USC 4305B2 and 12 USC 95A2. So this is explaining what each of the instruments are for. The enclosed bond is herewith tendered for discharging, adjusting, and settling future claims regarding account number 1, 2, 3, 4, 5, 6, 7, 8, 9. Explaining what the bond is for. And the interesting thing to note is that I set off the performance-based obligation, I discharged the present liability, and I provided a bond for any future liability. And I gave them all these instruments in one envelope. One envelope was a bond with bond paper with the commercial, with the medallion stamp signature guarantee. It was countersigned, so that's to be treated as a cash item. The other were 3 prepaid money orders. The other one was a payment order or a written instruction, right? So all these instruments are delivered via registered mail or delivered in person and have them sign for it with the receipt, but this information has to go to the CFO. It's pretty much for his own eyes only. And if you've seen in our fiduciary appointment cover letter, we're letting him know that it is confidential and he's not to disclose these matters. So at the same time, that payment order is deposit to the United States Treasury. So this is actually, I believe that it now becomes in a situation where he's really a fiduciary and he can't really accept or reject it because he's only an intermediary at that point. And the only thing he can do is either credit the account from the Treasury, which I believe he may already have the authority to do, maintain and manage his own books, or if not, present the instruments for payment and get a record of dishonor. But that won't happen because I've never seen the Treasury dishonor a debt that was presented to it to be paid. But neither here nor there, when I use this technology, I only received confirmation that the account had been paid off. And ideally, again, what if it hadn't, where my angle would be is I would simply get a notary protest on the instruments. Let me show you something about what is a notary protest. I found this document. This is some county in Ohio. Their bar wrote this document. Their bar association wrote this document. Unfortunately, I can't find it on the internet no more, so I can't direct you to where it is, and it's copywritten. But let me just read something from here real quick. Read about a protest. Negotiable instruments are normally negotiated by endorsement, right? Delivery, also called presentment, to the payer, which is then obligated to pay on the instrument unless it is dishonored. If an instrument is dishonored upon presentment for payment, meaning the party liable on the instrument does not accept it or refuses to pay, the presenting party may initiate a notarial protest. The protest is a means of legally proving that a presentment was properly made and the instrument was dishonored. So that's what I would do if they didn't release the claim or release the claim under the mortgage or the car note, whatever I was paying. I would do a notary protest on the instruments that I gave them to settle the account, because I would need evidence of that dishonor in order to have discharge. To initiate the protest, the notary presents the instrument for payment on behalf of the holder or bearer. If the instrument is dishonored, the notary essentially becomes a third-party witness to the fact of the dishonor. A notarial protest is a declaration in writing made by a notary public on behalf of the holder or bearer of a negotiable instrument which has been dishonored. The written declaration itself is also called a certificate of dishonor. The certificate should identify the instrument and set forth the time, place, and manner of presentment. It should also set forth the reason for protest, the purported reason for dishonor, if any is given, or the fact that the party could not be found. The protest should also certify that notice of dishonor has been provided to all necessary parties. The instrument of protest of a notary public constitutes prima facie evidence, evidence without further proof, of the facts therein, certified through the instrument may be, although the facts therein, although the instrument may be contradicted by other evidence, right? So this is a good place to end it, I would say. Just if you get positive acknowledgement of the debt being discharged, then congratulations. And if the fiduciary goes in the default, just continue out your process. Make sure you issue the 1099-C that the debt has been canceled. That's what I would do, at least. And of course, again, none of this is legal advice or anything like that. This is just what I've done in my experience. Lastly, before we get up out of here, right now I have available the most recent version of the guide Home for Free. And this particular guide focuses on the non-judicial process of adversarial possession, the right to take property, and then further how to take property without going to jail, and how to place the property in a trust to help mitigate the issues with transferring title. Because see, when you do adversarial possession on a property, should you be successful, you can't necessarily sell or transfer title to the property because you don't have clear title. So you might have to wait a certain amount of years, or you have to take further action to clear the encumbrances off the title so that you can transfer the title. But if you place the property in a trust correctly, you can transfer your equitable interest in the trust that holds the property. So you kind of don't necessarily need to transfer the title to the property, because you basically transfer ownership of the trust that holds title to the property. So that is one of the highlights of what I'm demonstrating in the Home for Free guide. And again, just like what I just did, what we just covered in the discharge debt thing, is just based off of research, what I've put together, what I've learned, and I'm still working out things and making things stronger. And but if you would like to support, send me an email and I will send you a link for the contribution of the guide. And thank you. So my email is coaching@thctrust.org. Peace.